Hi, welcome to Employment Hour in 30. I'm John Scholes. He's Lior Samfiru. We talk about your workplace rights and all that stuff each week. If you're just joining us for the first time, welcome. Come on in. Water's warm. We got a lot of stuff to cover. This is an important topic, an important show. That's why we keep doing it every week. I know we've got a lot of stuff to cover this week, Lior. In the meantime, you'll want to reach out when we're not on the air anytime. 1-855-821-5900 is a good phone number to start with. And we'll carry on from there. We'll get to the severance pay calculator. This is a tool that over 500,000 people have used and had their eyes opened up wide as to what they should be owed as far as their severance is concerned. But lots of things to get through today. We're going to talk about mistakes employees make because they just don't know any better. That's coming a little later in the show. But we always start every week with Lior with a segment we like to call the week that was. That's been happening in your office and around the firm. So what's going on?
John, every single week I talk to people that watch this show or listen to our radio show and want to ask questions about their matter. Usually it starts off with, I never thought I was going to have to call you, but here's what happened. Or sometimes it starts off with, I didn't realize I had certain rights until I watched the show. Well, that's great. That's exactly why we're here, because you may not realize you have certain rights. You may not realize that the law is there to help you and it's able to help you. So we're here to talk about that, to help you, hopefully provide some guidance, some comfort even, if you're dealing with a difficult workplace right. It's about your rights, employment law. So let's start off, as you said, John, a situation that came across my desk just a few days ago where I think there's some important lessons to be learned. It involved a gentleman who unfortunately got injured at work. So he was lifting something heavy. It fell on him. He hurt his leg. He hurt his back. Pretty significant injury. Older gentleman, and got hurt pretty bad. He did the right thing. He went to tell his boss immediately, and they said, please don't apply for WSIB. Please don't apply for WSIB no matter what. We'll work with you. We'll help you out, accommodate you, give you whatever you need. Just don't apply for WSIB. He went to see his doctor, and his doctor told him, you're crazy. You got to apply for WSIB. You may be off work. You may need some support, some financial help. You have to apply. So he did. And in fact, he was off work for about 2 months. He received compensation from WSIB, and he came back to work. Well, John, guess what was waiting for him on his day back? A nice, beautiful letter of termination.
Wow.
On his first day back. And no reason was given. The company wouldn't even explain why. They simply said, we're letting you go. And he called me right away. So here's the thing, John. First of all, the request or the demand not to apply to WSIB is illegal. An employer can't do that. An employee should and actually has to apply for WSIB if they get injured at work. Sometimes your employer may not want you to do that because they're afraid it's going to increase their premium, but your employer cannot demand of you not to do that. That's illegal in itself. So that's problem number one. Problem number two is it does look, doesn't it, that they're letting him go because he applied for WSIB or because he was off on a medical leave. That is a human rights violation. They're not allowed to do that. So this company really got it wrong. They made demands that are illegal. They fired him in a way that's illegal. It's a human rights violation. It can also be what we call a reprisal. And by the way, John, this is a 6-year employee that they offered 2 months' pay to. He's probably owed 8 months' pay. So there's everything wrong, all wrapped up into one. And remember, of course, if you're injured at work, apply for WSIB. You cannot be punished, threatened, convinced. You cannot be fired in any way. If you're in a situation where your employer treats you like the way this employer treated this person, call me right away.
I can only think that if the employer was a little, cheesed off that he took the time off and he came back, if they had waited 3 months, maybe 4 months, and then let him go, it wouldn't look nearly as fishy, right?
It would be very difficult to say at that point that he's being let go because of the medical leave, because there would be that distance. They're letting him go on the day back. Come on. It's not right. It's illegal, and there's going to be consequences.
EmploymentHourTV.ca is the website. You want to go there, check out all things have to do with this show as well, where to find out where you can catch our radio show and podcast as well. Each week on the show, as you know by now, we take calls from the radio show, play them back on here, and we get some perspective on them. Lior, we'll get to our first call for today.
I'm a sales rep, about 7 years, mid-40s, and half of my take-home pay is commissions. And sometimes our jobs that I'm working on go sideways. And so my employer decided to basically punish sales reps by not giving them their commissions, even if we get these jobs, because they're saying that, well, their profit margins are lower than they expected. They're not going to give us our commissions on that. Just wanted to know what your thoughts are.
Nice guy.
What a silly thing to do. Yeah. You don't need to be a lawyer to know that this is wrong. But what does it actually mean? If you've earned commissions, you have to get paid the commissions. It's as simple as that. It doesn't matter if it ended up being a good deal or a bad deal for the employer. If you've done what you're supposed to do to get the commission, the company has to pay it. There's no exceptions to that. Just like they can't say, well, I'm not going to pay your salary. They can't say, I'm not going to pay your commissions. Your commissions is part of your compensation. So that's very true for salespeople making commission. If you earned it, you have to get paid it. Now, if they're refusing to abide by their legal obligation, the law would consider that to be a constructive dismissal. Anytime your employer refuses to comply with its own legal obligations towards you, you may be able to say, no, I'm not going to take this. I'm going to leave and treat my employment as being terminated, and you, employer, have to pay me my severance. So that's what I would tell this person. You can treat this as a constructive dismissal and get severance. Of course, the next question becomes, John, well, how much severance does he get?
Right.
So let's take that information and apply it to the severancepaycalculator.com website, just to get everyone an idea how that works. So this gentleman is in a sales role, 7 years of employment. He said he's in his mid-40s. Yep. Well, someone in his situation, if he treats that as a constructive dismissal, would be getting 8 months' pay, right around 8 months' pay. So that's what's at stake for him. It's not a situation where he leaves and he gets, a few weeks' pay. It's 8 months' pay. It's a lot of money. It's a good period of time for him to find another job. So don't let the employer get away with not paying you what you're owed. There's a very basic relationship here. I come to work, you pay me what you owe me. It's as simple as that.
I think an important sidebar to that is also that if you're in the position where you get let go, and we've discussed on the radio show and this show as well, and you're owed commissions at the time of your termination, even though those commissions, they're not in the door yet, you've earned them. You still get those as part of your severance, right?
Excellent point, yes. Right. When you let go, or even if you leave, if you've earned the commission, right, even if it's actually not get paid till later, you have to get that paid because you've earned it. It's your money. So you have to get commissions even if you haven't received them in your hand by the time you leave. And remember, for commission people, when it comes down to calculating severance, we would look at average earning. So if I earn $60,000 in between salary and commission, that's my average income. That's going to be the figure that's calculated when we assess how much severance you're owed.
Again, employmenthourtv.ca is a resource to find out the podcast or listen to the podcast. Find a radio show where you can catch our weekly show, which we've been almost coming up on 7 years. We've been doing that. Phone call number 2 now.
I worked for this company like 25 years, and a new company bought them out. They said there's going to be no changes, all this stuff, and then everything changed. They wanted us to sign contracts and stuff, like 100 of us, right? So I didn't do it. Then they laid me off, and now they terminated me and gave me 2-week pay. So I don't know what to do.
Smartest thing of that is I didn't do it.
Exactly.
Smartest part of the call.
And some people may say, people that don't know what you and I know say, well, why didn't you just sign the contract? What's the big deal? Well, when a company that you're already working for is offering you a contract to sign, that's bad news, always. There's no situation where they'll say, here's a contract that makes things better for you, that gives you more rights. No. A contract, if you're already employed, is going to take away rights and make things easier, cheaper, better for the employer. So I can almost guarantee you, one of the things that this contract would have contained for this gentleman was a term that limited his future severance. So if he signed it and the next day he is let go, he would have lost tens of thousands of dollars in severance just by signing that piece of paper. Now, if they decide to let him go because he didn't sign, they're allowed to do that, but they have to pay him full severance. Now, this gentleman said he's been there for 25 years. Remember, the company inherited his service when they bought the business, so they can't let him go with 2 weeks' pay. In fact, after 25 years, he could be owed 2 years' pay, years, not 2 weeks. So this is a wrongful dismissal. He is probably very smart and very right not to have signed that employment agreement. And for our viewers right now, if you're working, you have a job, you've been there for a while, the company comes to you and say, hey, guess what, employee? We have a new employment agreement for you to sign. Be afraid. That's not a good thing. Let me see it if you want. Let me tell you what it actually means. But even without doing that, I can tell you that it provides for terms that are going to be problematic for you. You're better off, frankly, losing your job because then at least you get your full severance.
So in this case, quickly, 25-year employee bought by new owners gets severance paid by the new company or paid by the outgoing company?
So because he actually started working with a new company,
Right.
they inherited his service. So when they let him go, they have to pay him severance. Now, if he had lost his job as a result of the sale transaction and he
Right.
never had started working with the buyer, then the old company, the first one, would have had to pay him severance.
Again, our topic for this week is mistakes employers make because they don't know any better. I love this topic because this is what really enlightens people about the shows when we go through. You've got it down to 6. We could have done 166, but we've got it down to 6, right?
Yeah.
Important topic.
It is an important topic, and it's a topic that many employees are going to be surprised by because they would figure my employer must know.
Sure.
They're more sophisticated, they have experience, they have HR and legal help, so they must know. Well, believe me, there's so many mistakes employers make. Oftentimes they make them as mistakes because they hope they can get away with it, but in many other situations, which is what we're going to be talking about today, they make those mistakes because they don't know any better. So we want to talk about that, and it's up to you, the employee, never to assume that your employer knows better or that your employer must be doing the right thing. You have to make sure that your rights are enforced. That's why we're here.
Number one, and really the reason why we started the radio show and this television show weekly as well. Number one, when terminating employees, employers only provide severance under the ESA or the Employment Standards Act.
So very simple, very clear, and very common mistake. Employers oftentimes do not realize that over and above what the Employment Standards Act provides, there's additional termination entitlements under the common law. So the Employment Standards Act provides your minimum entitlements, which could be a week's pay per year of service. But your full entitlements, your common law entitlements, could be 10 times that. And oftentimes employers, oftentimes smaller employers, may not realize that. They may even call the Ministry of Labor and they say, how much do we have to pay an employee? And they'll tell them the minimums, except that is wrong. That is only a portion of what you're owed. So you're in that situation. You're looking at your severance letter and that provides you for 3 weeks pay after 3 years of employment. That is wrong. You could be owed 6 months pay. So employers get this wrong all the time, and now you know better.
Mistakes employers make, whittled down to 6. We'll get into number 2, putting an employee on a temporary layoff, thinking, it's okay to do. We can do that.
A lot of employers do this, and a lot of employers get this wrong. So let's be very clear. A temporary layoff is a termination in most cases. You don't have a right to do it. Employers believe that they do, and they believe that I'm not letting you go. I'm just going to put you off, on ice for a while, and I'll call you back in a few months if things get better. Well, the employee can accept that, and that's okay if they want to do that, but they can also treat that as a termination. And then all of a sudden, the employer says, holy cow, now I have to pay all the severance. That's the way the law works. So remember, a temporary layoff is a termination, and employers get this wrong all the time.
And the hazard if the employee accepts it even once? For the first time?
If you accept this, your employer puts you on a temporary layoff, puts you on ice, as you said, and you say, okay, I'll be the good soldier, I'll go at home and I'll wait, and you come back. By doing that, you've given them the right to do it again. And that's the problem. The first time you do it, you give them the right to do it a second, third, and fourth time, and then you can't do anything about it. Then your job is no longer secure. It's a bad situation to be in, so don't let your employer do it.
By the way, anytime you want to reach out, 1-855-821-5900. Get a hold of Lior, member of his team, his very able crew. We are talking the top mistakes that employers make. Number 3 is not properly distinguishing between the old independent contractor and the employee.
We can and we have and we will continue to do shows just on this topic. So this is a big one. The employers believe that if I call someone an independent contractor and they sign a document saying that they're an independent contractor, then that's it. Nonsense. The law makes that decision. Employers get this wrong all the time. They misclassify employees. So they give people jobs, but they call them independent contractor. It doesn't work that way. So if you've been misclassified, you have the rights of an employee. Overtime, vacation pay, minimum wage, termination and severance pay. So very important to remember that just because you signed a piece of paper believing that you're an independent contractor, it does not make you one.
Help@employmentlawyer.ca is the email address, by the way, as we carry on here. The big mistakes that employers make. We're into the top 6. That's what we got it down to, number 4. And in this day and age, this actually still happens. Employers don't take harassment complaints seriously.
Yeah. Can you believe it? In this day and age especially, well, employers don't do that because they think, well, it's not our problem, or, oh gosh, the
boys will be boys.
Boys will be boys. What a silly, silly idea. So what do employers have to do? They have to investigate harassment complaints. Well, first of all, they have to take it seriously.
Yep.
And then they have to investigate, even if it means bringing in an outside investigator, and then ultimately take measures to fix the problem, to eliminate that harassment. Employers can't ignore it. The old way was to say, well, that's not my problem, that's your problem. You guys figure out how to get along. You can't do that. Employers get that wrong all the time, and the law sees doesn't give the employer the right to do that.
Number 2, or at least 2 more to go. Number 5 is firing an employee for cause when they don't really have cause.
So the employers often would jump the queue, so to speak. So the employee may have done something wrong.
Yeah.
The employer doesn't build up its case, and they still let someone go for cause. Employers assume often that just because you did something wrong must mean I should be able to let you go for cause. It's your fault. Not so fast. It doesn't work that way. Even if the employee did something wrong, unless the employer properly built its case up with warnings, maybe with suspensions, the employer cannot let the person go for cause, which means if they do let them go, that's a wrongful dismissal. They owe them full severance. So it's very difficult to terminate for cause.
The big mistakes employers make, the last one is one, I mean, this is a part of the ignorance of the employee as well. I don't mean that in any bad way. Everybody just assumes that probationary periods are automatic.
Absolutely. People assume, employees, employers, that I just started a job, I'm on probation for the first 3 months.
Yeah.
No, not so fast. There is no such thing as automatic probation. There isn't. Probation has to be created in an employment agreement. So the only time you're on probation is if you sign an employment agreement that says, say for the first 3 months, you are on probation. And if it doesn't say that, or if you did not sign an employment agreement, by the way, that's a good thing, then you're not on probation. You have all the rights of an employee on day one, especially when it comes to your severance. If you're not on probation, you get your full severance. And by the way, even sometimes if you are on probation, you still may get severance.
To reach out, 1-855-821-5900. You got employmenthouertv.ca. We'll take a short break. We'll get into the maternity leave mishap and the severance pay calculator after that break. Stick around.
Lost your job? Employment law myth number 7. Involving an employment lawyer is expensive. Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
Yeah, welcome back to Employment Hour in 30. Anytime you want to reach out, catch Lior and his crew, 1-855-821-5900, and employmenthourtv.ca as well. SeverancePayCalculator.com. We are going to hammer that website into your brains for eternity, till everybody who has a job in this country knows how to use it and checks it quite frequently, right?
Everyone needs to know about it. Everyone needs to know about it because it's so important. It's such an important tool. It has and it will continue to save people thousands and thousands of dollars every single day because it provides you the information you need to know what you're owed if you lose your job. So SeverancePayCalculator.com. Again, SeverancePayCalculator.com, the place you go to if you lost your job, even if you're not losing your job, but you're worried about it. You know, things happen, changes happen. Maybe your business has been sold and you want to know what happens if I lose my job, or you're maybe curious. Once you go to SeverancePayCalculator.com, you'll be asked a few questions. How long did you work? What kind of a job did you have? How old are you? Just pick it from a drop-down menu. It takes seconds, and then you're done. You find out how much you're owed, the real amount. It's free. It's anonymous. You don't put in your name, the company's name. It's just there for your information. Check it out right now. Well, actually, wait a few minutes. Wait for the show to be over, and then grab your smartphone. Go to SeverancePayCalculator.com, input that information, and now you're armed with that knowledge. And definitely, if you're walking out of that termination meeting, severance papers in hand, before you even hit your car, grab your phone, SeverancePayCalculator.com. You may be surprised by what you see.
We could talk about it all day, but examples are best. We'll get to one. Marco was hired by a local construction company as a general labor. After 10 months on the job, he was suddenly let go. He's out of there. When he asked if he would receive 2 weeks' pay as severance, his supervisor told him that severance rules don't apply to the construction industry. Marco, forget about it. You're out of here. Is that right?
Well, John, how many times have we heard this on this show, on our radio show, this idea of construction, the misconception. One of the biggest misconceptions out there is that construction employees don't get severance. Yes, I said misconception because it's false.
Yep.
Construction employees, not only do they get severance, John, they get the same amount of severance as every other employee based on the usual factors, age, position, and length of employment. So that's false, what Marco was told. But let's actually tell him how much he's owed, and let let's allow everyone to see how the severancepaycalculator.com website works. So we've inputted the information to severancepaycalculator.com. You can see it on your screen right now. So he's a laborer, 10 months of employment. I picked an age, let's say he's 56 years old. So even after 10 months of employment only, he still gets about 3 months severance. You can see that on the screen right now. So we went from, you don't get any severance because you're in construction after 10 months of employment, you get 3 months pay. And by the way, John, how much severance do you think he would have gotten if he worked 2 years, 5 years, 20 years?
Right.
A lot more, right? Yeah. So that's why the severancepaycalculator.com website is so important. Check it out. Construction, any role, full-time, part-time, young or old, works just the same.
EmploymentHourTV.ca, great resource to find, as I mentioned earlier in the first segment, to find where you can catch our radio show and listen to the podcast of that show. Take a ton of phone calls. We chop them up. We play them back in this show, and I know you want to talk about it.
My sister, she had been working in a job for 10 or 15 years. She ended up going on mental health leave. She wasn't approved by her insurance company, and she continued to go on leave, but the employer will say, do you have an update from your doctor, and ask her for an update. And I'm just wondering, would she be entitled to any severance if they wanted to get rid of her?
Not so fast.
There's a lot of stuff there to kind of dissect. First of all, if your doctor is saying that you can't work, but your insurance company says we're not approving you, that's an issue right there, okay? If you can't work, if you have a doctor supporting you, your insurance company should be paying you. Your long-term, your short-term disability insurance should be paid to you. That's why it's there for. Except, as we know, we've said before, oftentimes insurance companies are in the business of trying to say no so that hopefully they can get away with it. So right off the bat, for this person, for any person, if your insurance company denies your long-term disability claim, it's wrong. Give us a call. Let's talk about that, because oftentimes we can either get you compensation or get you reinstated back on the plan. Yeah. Now, to this specific question, if she is fired while she's on disability, it would probably be because of the disability. That's illegal. So that's a human rights violation. So yes, of course you get severance. You get severance if you're let go when you're on a medical leave, but you also may be getting human rights damages because you cannot be let go because of a disability. That's illegal. Now, if you're let go because of a large restructuring, then it may not be a human rights violation. You still absolutely get severance.
Maternity leave misstep. That's where we're going to go after a short break. 1-855-821-5900 and EmploymentHourTV.ca. Employment Hour 30 continues. Hang on.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact: the labor board cannot help an employee get their full entitlements. Always go to EmploymentLawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 7. Involving an employment lawyer is expensive. Fact: in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to EmploymentLawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. It is EmploymentHourTV.ca, the resource, the website you go to find where you can catch our radio show, download the podcast, and listen back to 6.5 years of fantastic radio show in the Employment Hour. We take a ton of phone calls on the show. We play them each week here on this show. And we'll get to another one. Lior, I know you want to comment and make some comments on this call.
Currently on mat leave, supposed to go back to work here in the next couple months, and I've been told that my position, manager role, no longer exists due to budget cuts. Been there for 10 years with the agency. They've offered a severance. The severance that came out, I don't think reflects the time that I've been there. It's the 6 weeks termination, but nothing comparable to what I was making, $70,000.
Well, you know, obviously, anytime you deal with someone that's on maternity leave and they come back either to no job or to a different job, I get suspicious. Yeah. I really, really do. Because the law couldn't be clearer, okay? The law is very clear when it comes to maternity leave. The employer's obligation is to take the employee back to the same job, the same pay, okay? So it's not rocket science. And if the employer doesn't do that, the first question I ask is, well, why? Is it because they are upset that the person went on maternity leave? Is it because they're worried they're going to go back on another maternity leave? Do they like the replacement better?
Yeah.
None of those things are legal. Now, the only time that your employer does not necessarily have to take you back to the same position is if legitimately that position no longer exists. Regardless of whether you're on mat leave or not, the position was eliminated. It's a business move, has nothing to do with you. It's a restructuring. Okay. then at that point it's not a human rights violation, but severance still has to be paid. So with this particular caller, the first thing I'd want to do is investigate, do we believe that this lack of a position or that the change in position, do we believe that it has something to do with the maternity leave? Because if it does, it's a big problem. If it doesn't, then it's just a question of severance. And to assess severance, again, let's go back to what we were saying before, severancepaycalculator.com, just to have our viewers see how it works again. Let's plug this person's information into the severancepaycalculator.com site, and let's see what we get. So she's a middle manager, she says, 10 years of service. I picked an age, let's say she's 32 years old. She made $70,000. Now, they offered her 6 weeks' pay. Okay, well, 6 weeks' pay. Some people may think, well, maybe that's not bad. Guess again, no. It is very bad. Severance calculator correctly assesses as her being owed 12 months' pay. Now, that's a difference of some $60,000 plus, okay? And again, we didn't pick this call because it was unusual. In fact, we picked it because it's not unusual. We picked it because it's a common situation. Maternity leave, getting paid a lot less severance than you're owed. That's why the severancepaycalculator.com website is important. That's why you have to reach out, call, or email so we can talk about your matter. You may have very significant entitlements.
And you may have questions as well. Another resource for you to go to is terminationquestions.com. Check it out. Ask your question. There's a drop-down menu. There's a fairly high probability that that question has been asked and answered in depth. If not, do so. Leave it. Lior and his team will answer it. We'll get to one again. Terminationquestions.com says, I've been working the same part-time hours at a company for the last 2 decades. Now they want to drastically reduce those hours to the point where I might as well just quit. Is that my best option?
Well, it is, but except it's not really a resignation.
Right.
So if your employer is going to change your hours and obviously your compensation, that's not something they have a right to do. Which means if you leave as a result, that's not a simple resignation, that's a constructive dismissal, okay? And that's a very common situation. Your employer starts changing your schedule, your hours, your compensation. They can't do any of that. So if you leave, you get severance. Now, the important thing to remember is you have that choice, right? You don't have to leave, you can continue working. But if. So number one, if you continue working in this particular situation, number one is they've given their employer the right to do it again. Problem number one, big problem. Yeah. But if they take less money now, and then a month later they're let go, now their severance is calculated based on this reduced amount. Right. Even though maybe for 10 years they're making more money and they're making less money just for a month, that is enough to reduce your severance. So if you're going to be losing your job, you want to lose your job at a time when you're making as much money as possible, because that's going to increase the amount of severance that you get. So I would tell this person, do you quit? Yes, you quit. We probably want to draft a letter to your employer letting them know that I'm not quitting because I want to spend more time on the golf course. I'm quitting because of these changes. I can't accept these changes. And then we pursue the severance. Got a couple minutes left. I want to slide this one in quickly. Again, terminationquestions.com says, I've been watching your show, good, for the past few weeks, and now realize that I should have received severance pay after I was fired. Can I still call you? I was fired almost 2 years ago. Almost. That's key. You know, it's, I hate the 2-year calls because I'm like, oh my God, I have to do something before the 2 years are up. Right. So there's a 2-year limitation period, Johnny. 2-year limitation. It's not 2 years in an hour, 2 years in a day. It's 2 years. So if you pass that by even a day, you're too late. You're out of time. But please don't call me when the 2 years expires tomorrow. We may not be able to get it in on time. So take your time if you need to assess it, but 2 years is a long period of time. Call me before, let's assess your situation, and let's get you the severance that you're owed. There's no reason to sit on your rights for 2 years. And if you do, please make it a year and a half if you have to. Yeah. Give me the time I need so that I'm not have to send someone running over to the courthouse to preserve your limitation period. So if they're under 2 years, they can still call, and you should be. Hopefully it's a few weeks out. You should be able to slide in there. Yes, absolutely, right? Absolutely. I've had people call me 2 years in a week. I've had people call me 7 years later. I mean, bottom line is you have 2 years to pursue your rights, and that applies, by the way, human rights, it applies to constructive dismissal, it applies to unpaid overtime, unpaid wages, wrongful dismissal. There's that 2-year limitation period, but it's a strict limitation period. In fact, in some situations for human rights, there's only a 1-year limitation period. Okay. So best advice I can give any of our viewers, please don't sit on your rights. You got a minute to go. Plug the severance pay calculator once again, because I know you'll love it. I love it, and if you use it, then you'll realize how much you're owed. You'll love it as well. Severancepaycalculator.com. If you lost your job, you need that information. It's information that employers use as well. Yeah. Employers that want to do the right thing by their employees, go to severancepaycalculator.com. Now, it provides an assessment. It gives you an idea of what you're owed, and it allows you, if you want, there's a nice little green button there to contact me right from the severancepaycalculator.com website to allow me to help you get what you're owed. So severancepaycalculator.com.
Done for another week. Moving forward, you want to contact Lior, 1-855-821-5900. There's help@employmentlawyer.ca. That's an email address. And again, for all things about the show and the radio shows, go to employmenthourtv.ca as well. Glad you joined us this week. We hope to see you next week right here on Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.